Welcome to Agri Extra at Nampo Virtual. Today I'm joined by Advocate Thembeka Ngcukaitobi, a man who has written quite extensively on the issues of land reform, land restitution, and in general the policy failures over the last few years. Today Thembeka is going to be discussing with us an issue that has arisen in his next venture, I must say intellectual venture, that he has embarked on, which is a book called Land Matters. Thembeka, welcome to the studio.
Yeah, thank you. Thank you for inviting me.
And you have been having a lot of interest on the land question, and I must say you're quite industrious at it, because on the one hand you are running a successful practice as a senior counsel in the Johannesburg Bar. Yeah. Occasionally you act as a judge at the Land Claims Court, but of course we are here today in your private capacity as an author, researcher, thinker and writer on this matter. Your next book is called Land Matters, and that's where you want to try and debunk the myths and try to explore the complexities of this question, and also expose some of the intellectual short-sightedness of our politicians and policymakers. But let's start with the issue of restitution, because that's where the post-apartheid system had so much promise in terms of getting people their dignity through restitution. What has happened there, and what do you consider to be the challenges?
Yeah. So firstly, we must just disaggregate the concepts. So if we start with what is restitution and how does it differ from other programs of government. So basically, this is what transpired. In 1994, a big discussion, perhaps it started in 1992, right up to 1994. The big discussion is, how do you resolve the effects of the 1913 Land Act dispossession? And there were several acts in total. I counted about 4. The most important act, it was 1913, 1936, 1951, and 1960. And those 4 legislations is basically the acts related to the Native Land Act and the acts related to Group Areas Act. The consequence of both of those acts combined was that approximately 3.5 million Africans were forcibly removed from areas that were classified for occupation by so-called Europeans. So the big question between 1992 and 1994 is, how do you undo the effects of forced removals? And the way that the ANC decided at the time in its Ready to Govern document was that this would be done through what was called a restitution process. Yeah. So you identify a specific piece of ground, you identify a specific family, and you identify a specific incident of dispossession, and you try and restitute the land back to the community or the individual that lost the rights to the land. Yeah. It was accompanied by another program called redistribution, which was not based on an identifiable act of dispossession, but it was based on need.
Yeah, especially among the previously disadvantaged.
Yeah, primarily Africans, let's call a spade a spade. So it was basically the African community who were the primary victims of forced dispossession. So if we then go back to your question about restitution. So restitution was intended to undo the effects of forced removals. We have approximately 3.5 million people that were meant to be the beneficiaries of restitution. So take them back to where they came prior to the forced removals of the 1913 Land Act and the Group Areas Act. Yeah. So where the problems have been, there have been several problems with restitution. The one problem is an obvious one, which is the cutoff date. Restitution begins on the 19th of June, 1913. And the problem with the cutoff date is that by that stage, approximately 93% of the total land surface in South Africa had been taken over for European or white occupation. So from the onset, its true transformative reach was constrained, constrained by an imposed date of 1913, which was linked to the Native Land Act itself. So that was the first problem. The second problem with the project of restitution is that because it was not driven by need, it depended primarily on evidence. You had to prove as an African person that you were dispossessed at a particular time, at a particular area. And because it was taking place almost 100 years after the initial act of dispossession, evidence disappears. And so what that meant is that claimants depended primarily on researchers to collect the evidence needed to prove their claim. The third problem is that the process is entirely judicialized. it depends primarily on courts. And it does not depend on policymakers or on the administration or on government. It's a highly judicialized process which is adversarial in its nature. So you have to prove your case as if you are proving a claim for damages. And yet you are resolving a socio-economic structural problem as opposed to a particular legal
But there was
claim.
also this intergenerational exchange of hands over the property over a period of time.
Yes. So in addition to proving dispossession, you had to prove that that dispossession was a consequence of racial discrimination. You know, in the 1993 Constitution, the phrasing was of an act that would have been discriminatory had the current Constitution been applicable. You know, so that formulation remains. You have to show that it was not just that I was dispossessed, but I was dispossessed in the furtherance of racial discrimination. And most landowners denied that there was racial discrimination. What they claimed, which they currently still do, was that if you look at me as the current owner, I have nothing to do with racial discrimination because the land was acquired, quote unquote, in the open market. And the fourth problem that has been a constraint has been the way in which the land is paid for. The government has tended to pay people on market-related compensation, and it has tended to pay them in cash. And both of those, the amount that is paid and the method of payment, which is cash, are not provided for in the Constitution. So on the one hand, we've got deep-seated structural constraints, but on the other hand, we've got just blatant policy failures where the government just doesn't do what it is supposed to do.
But on the last question, I mean, the government says it's people's choice to accept cash. The government can't impose on them what they should demand. I mean, many people would say, okay, the option of having land vis-a-vis cash, I'd rather have the cash.
Yes, that's been one of the major failures of land restitution. It is the idea that the government gave people the option to settle for cash. In fact, I think 93% of all urban claims were settled on a cash basis. But cash does not resolve the problem of landlessness, because what typically happens is that a payment is made for a land claim, but that very person comes back to stand on the queue for RDP housing, because the true hunger was land and housing. But the way that hunger has been cured was through cash. And cash is easily dispensed with and spent. And thereafter, the cycle begins again and again and again.
But then how do we cure all these four limitations you have outlined going forward? Because we can't get stuck in criticism. Somehow there should be movement. And I guess that's some of the things we are trying to propose in your book. Yes,
I mean, one of the solutions that so let's identify one area and look at the solution. So one of the big problems has been that most land reform thinking in South Africa in the post-1994 era has looked at restitution as the cure for all problems of landlessness. So the first big solution is to think of restitution as an element and not the solution. In other words, as part and parcel of a bigger package, right? So our obsession with restitution needs to be tempered a little bit. So restitution is limited because of the 1913 cutoff date, but it is also limited for the structural reasons. So what in fact is going to cure the problem of land hunger is not restitution, but it is redistribution. So that Africans do not have to prove dispossession, but dispossession can be assumed that if you're black in this country and you have no land, it is most probably because it was taken away by white people using force and violence or trickery. And I have many, many examples of trickery and forced violence that are contained in my previous book, but I have some in the current book. So the first big solution is to start shifting away from restitution and thinking about tenure and thinking about redistribution as ways of acquiring land. Redistribution has its own advantage because it does not have the emotiveness of restitution, because you don't need to accuse any current owner of land as having acquired that land consequent upon racial discrimination. And what it simply focuses on is you need land, land is available, and it should be acquired on reasonable prices. So that's solution one. Solution two is to think about compensation for acquisition of land. Two big problems is paying cash and paying it at market-related compensation. There is no warrant for that. There is no reason to pay market-related compensation. That is not the same thing as saying that we should be paying, we should not be paying anything for land.
But who's not entitled, in your opinion, to market-related prices? The white owner or the the beneficiary who chooses money over the land?
No, no one is entitled to...
Neither?
Neither is entitled to market-related compensation. That concept simply doesn't exist in our constitution. But on the current framing, both, in fact, get market-related compensation, so-called market-related compensation. White farmers have insisted on market-related compensation throughout. When I have sat in the Land Claims Court, the primary demand from white landowners is that they should be compensated on market-related prices.
Yeah.
And property valuers, have come up with this idea that it's impossible to fix upon a price that is dependent on justice and equity, and that's why their natural reflex is market-related compensation. So the second big solution to it is to dismiss the notion, which is really a myth of market value, is to think about a different way of compensating. And then the third solution is to think about how, in fact, that money is, or whatever forms of compensation are paid. We tend to pay cash, and we tend to pay cash upfront. The result is that the land is not transferred until a market-related compensation is paid, and it must be paid in cash, and it must be paid upfront. So take one case, it's rather become a famous judgment, the Msiza judgment, which I adjudicated when I was a judge in the acting judge in the Land Claims Court. The land itself was transferred to Mr. Msiza in law. I mean, he never acquired, transferred to him in 2004.
So he got the title?
Yeah, he was entitled to the title, but it was never passed to him because the payment had not been made to the owner in order to pass the title.
Yeah.
So what he had was a piece of paper called a court judgment that says you are entitled to this piece of ground.
But the government still had to pay.
Yes,
the
in
owner.
order for the title to be transferred. So this was in 2004. The case came before me in 2016. That's 12 years after the event. 12 years after the event. Now, if you think about the fact that 2004 was the judgment date, and if you look back at when exactly was the claim made, the claim was made in 1998. So we're talking about a claim that has been in the system for 20 years, right? Now, that is the typical land restitution claim.
But so what do you ascribe that to? Would you say it's bureaucratic inefficiency? Would you say it's lack of money? Would you say where do you locate the needle in terms of the problem area there?
I think the one problem is the over-judicialization of this process. I mean, if you had a system similar, for instance, to the CCMA, in terms of which you lodge a claim, there are 30 days to resolve the claim, there are 6 months to take it through the court process, there's another year to take it through the appeal process. So a much more regimented land claim process than you currently have at the moment. At the moment, you have a judicialized process where essentially the winner takes all. So if you prove your case, you get everything. If you fail to prove your case, you get nothing. So we have a judicialized process that works on the winner takes all basis, just like any other claim. What we have forgotten is that what we are trying to resolve here is not a motor car accident, and we're not trying to apportion fault or liability. What we're trying to do is to resolve a problem of justice.
Would you say the same of the Richterveld case and the fisherman's case in the Eastern Cape, as well as the District 6? Would you say all of those are part of the over-judicialization of the process?
Yes, they are, particularly the District 6 case. It's clearly part and parcel of this process that must be run through a legalized and overly legalized system, which is not focused so much on ensuring that there is a settlement which probably would have been arrived at through a mediation or a mediated or a negotiated outcome. But it is focused on winning a case. And winning a case has its own advantages for the winner. But the person who loses, say for instance someone is unable to prove that they were a community, even though there is a sense of injustice, what has happened is that there is a legal element that they've not been able to overcome. And yet, if they had negotiated the solution themselves without the intervention of lawyers, a solution that is much more sustainable could have been arrived at. But both parties in this instance, essentially everybody wants to win. Landowners want to win heads down. And the same thing with the land claimants. So you want to win or lose.
Is it not that people feel safe, sort of a little bit more comfortable in the confines or working within the framework of what they consider to be legal, in the presence of a judicial officer who is much more respectable to all?
No, I mean, my argument is not to criticize the judicial process, but it is to outline it as a limitation, which was your question, is what are the constraints? So this is not to say that we don't need a judicial system, but it is to simply acknowledge that a judicial system is a constraint to the speed at which land claims are.
And it should not exclude other avenues.
And what we should really be looking at is what role should the judicial process play? One of the roles for the judicial process is to serve as a quality safety valve. But the primary mechanism for the transfer of land is negotiated, whether it is mediations or is driven by the bureaucracy, whether it's driven by the commission. And what you have is that the judiciary really becomes the last port of call. Where the problem is where the judiciary becomes the first and the last port of call.
But the way I understand the system, I mean, it's not as if all of these avenues are precluded by the current legislation from happening.
Yes, but that's
they're not precluded at all.
No, that's right, and that's part of the problem of the sort of. I mean, I wrote a paper in which I said the crisis we have on land is a crisis of not lack of land or lack of resources, but lack of imagination, because mediation is in fact in the Restitution Act, but mediation is simply not used. The same thing as an investigative process, which is driven by the Commission for Restitution of Land Rights Act. It is contained in the Act. The problem is, again, that it is not being used. The same thing with negotiating payment. That is contained in the Act. The same thing with whether to pay cash and to pay it upfront. That is provided for in legislation. The same thing with market-related compensation. That is provided for in the Constitution. So what you have a totally unimaginative government that is meant to be at the center of land reform, but that has completely wasted the past 25 years.
Now, let's move to now, if you say the solution perhaps is to move towards redistribution, because then we will avoid the limitation of a specific time frame, and we will avoid the limitations around definitions of who's the victim who was removed, and we will take it that generally black people need land, whether it's for settlement or agricultural purposes. Now, let's move to that part now. How would that work, given the limitations we've had so far? I mean, at some point, the government had a target. I think in 1999, there was a target that by 2014, 30% of land that needed to be distributed to, well, there was 30% of all commercial land, if I'm not mistaken, would be in the hands of black people. But until today, we are now at 2020. That target has not been met. I'm not sure whether half of it has been met. So what should be different now if we have to adopt what we are proposing?
Look, the target comes from the ANC's RDP document passed in October 1994. The target was that in the first 5 years of the new government, 30% of agricultural land would have been transferred to black hands. So in other words, by 1999, the target was that we should be having 30% of agricultural land. And how that target came about is also an interesting story. They worked out what transpires in the ordinary commercial market. And they discovered that about 6% of all farms exchange hands per annum. And then they looked at 6 multiplied by 5, and then they said, okay, if we work around 30%, that is realistic. So by then already, they had seeded the just and equitable notion into looking at what happens in the markets, and that's why they thought they were comfortable with the target of 30%. The reality, however, was different. By 1999, it was something like 1% of agricultural land that had been transferred as a consequence of the government program. So ordinary commercial activity was still taking place. People who were able to raise enough money were still buying land. But the question was whether or not the program of government, which promised to transfer land, was succeeding or not. So by 1999, 1%. Today, the numbers are disputed, but everyone agrees that the number is still less than 10%.
Actually, I must correct myself, because it was when that target was not met in 1999 that as Ken was kicked further down. And the target was shifted to 2014. And again, the target was missed.
It's impossible to meet that target on the current trajectory. The researchers that have looked into this area, they've decided that I think it will take us another 178 years or 148 years, but it's like an impossible number to meet 30%, not to meet the full demand. So meeting 30% on its own is going to be an impossible target on the current trajectory. So what that means is that we need big solutions, and it's not going to be enough to allow things to move the way they are. So what we need are huge solutions in order to make some progress, even in relation to the so-called 30%. What it also means is that we also need to be looking at solutions that are not driven primarily by the state. We have to be looking at a multiplicity of solutions and not only state-driven solutions.
But at the moment, I mean, if we can just zone in what people are expecting of the state. At the moment, the big debate in the country, and it's been raging for a while since the advent of the EFF, has been the whole notion of expropriation without compensation. And the EFF has popularized this debate, and everyone now talks about it. And subsequent to that, the ANC took a resolution at its 54th conference at Nasrec to the effect that there must be expropriation without compensation. And Parliament is now seized with this question. Although there's a history around it, which you talk about in your book, how viable is that option?
Yes. Look, I mean, I suppose there are two questions to be raised on expropriation without compensation. The one is whether or not the country needs a model of an expropriation without compensation as part and parcel of, a larger policy responses to land. The answer to that seems to be simple to me. The country obviously does need a model of expropriating land without compensation. It is impossible to think of a country like South Africa with such a racialized history of dispossession, which basically primarily happened through the barrel of the gun. I mean, white people from Europe started by genocide, and thereafter they started by wars. I mean, so the history of this is recorded. So if you want to undo 360 years of forcible dispossession, it is impossible to do it primarily through a market-based system. The market is not the solution to it. The question then becomes, under what circumstances should expropriation without compensation be utilized? Because there is obviously a risk with an unbridled expropriation without compensation regime, that instead of resolving the injustice, it will perpetrate injustice.
If you just expropriate randomly.
If you expropriate randomly. And what it will do is to concentrate power to the government as opposed to distributing land to people who actually need it. So the question is a much more sophisticated one, which is we do need a system of expropriation without compensation, but we need it to be targeted, we need it to be proportional, and we need to identify specific categories. But most importantly, we need it to be supervised by the judiciary.
So are you not going back to the over-judicialization of the process?
Certainly in relation to loss of land, the actual loss of rights to the land, what you need is that whether the judiciary plays the overall safety valve and the overall review mechanism, we still need to install the judiciary as the final point of reference to questions about who loses rights to land. So I would say in those instances, the judiciary is vital. In fact,
we are not saying the judiciary should be part of the administration process leading to the decision or whatever, but you are saying that whatever decision is taken in the expropriation process should be judicially reviewable. So people have an option to go to court and say, listen here, I want to test whether this process was rational or whether it was justifiable remedy.
No, exactly. I mean, so your typical expropriation works like this. You have decision 1, which is the expropriation decision, and then you've got decision 2, which is the compensation decision. Decision 1, which is expropriation, that's taken by the government. But if you are aggrieved as the owner of the property or as the claimant to the land, you are entitled to go to court. But the court is not playing any role in the identification of which land. And that court then plays a review role. So that role is crucial because it's the role at which there is a potential conflict. And that conflict must be resolved by the application of law. The second big decision is how much should be paid. So the first decision there on how much should be paid, that should be made by the government. The government must make you an offer. And you will be entitled as the owner of the property to make a counter offer. Alternatively, to accept the offer that the government has made. But if there is a conflict about the money, the question is who should resolve that conflict? And that's where the judge's role is crucial. So on both the scenario of taking the land and as well as deciding on the payment, I don't see the judge's role as necessarily a primary role. I see it as a secondary role of reviewing the process and deciding if your rights have been properly protected.
Yeah, but there will be another question about who deserves to get land that has been expropriated.
Yes, that is a key question
because
for
all black people presumably need the land.
Yes, that is a key question for redistribution. So if we look back at the program of redistribution, it's contained in the Constitution. And it's also a very fascinating story that I tell in my book, that the ANC's original conception of how to resolve the problem of dispossession was not restitution, it was redistribution.
Yeah.
The ANC always thought that restitution would be a complicated affair.
Because of the history.
Because exactly of the history and the ways in which you identify who was dispossessed at what point in time and what evidence you have. And so its conception was to think that the solution to land reform was redistribution. In other words, people must get land based on need. You know. But what happened is that shortly after the Constitution was adopted, redistribution was completely jettisoned and forgotten. And that a lot of energies were then spent on restitution. Despite what you can now look back at the past 25 years and see that the program of restitution was constrained from the beginning. So redistribution was always the proper instrument to deal with the crisis we have in South Africa. It is true we have a crisis of history, but we have an ongoing crisis of need. And the way to resolve that is to think about redistribution. So first question with redistribution, which I identify as one of the constraints, is the veto or the veto of landowners. Landowners decide which land becomes available because land is acquired in the market. And there are primarily three mechanisms of land being available. It is either it is transacted on an individual basis, or it is advertised, or it is sold in an auction. That is how land becomes available in this country. On those three mechanisms, it's the landowners who decide which land becomes available. So one needs to break that stranglehold of land availability, which is currently vetoed completely by landowners.
But the government also has a leeway to get land, because in terms of the law as it stands now, they can expropriate land for public purpose, well, to build a road, to build a hospital or whatever.
Yes, that is largely driven by the state whenever they decide that a school is to be built, etc. But that does not resolve the problem that we are confronting now, which is not to take the land for purposes of building a school, but to take the land in order to pass on to a private owner who will use it for settlement or who will use it for farming. And that's where the distinction is, because we are talking really about redistribution in the public interest. In other words, if we are to use a simplified language, to take land from potentially a white farmer and to give it to a group of black farmers to continue the same operation of farming.
Well, there's another dispute about, this expropriation issue, other than the whole issue of whether there should be compensation or not, which is one dispute in the whole debate. But there's another one about when you expropriate, should the state become the custodian of the land, which then can be used by whoever the state decides should use, but the land nonetheless, the title is not passed to the individual private person, but the state remains the title owner of the land. What is what? Which one is viable here?
No, I completely disagree with the idea that the state should take custodianship or ownership of the land. The reality is that there are very few countries that we can think about, certainly in the African context, with viable, robust, sustainable agricultural communities where the state is the owner of the land and parcels it out as it pleases. Particularly in the context of our own state, we have had a thoroughly corrupt state inside out. To give it an extra power of controlling and parceling out land seems to be a dangerous idea. What we do need is we need the state to play the role of facilitator, in other words, acquiring the land but distributing it and giving the responsibility to those who own it or hold it. I think there is something to be debated is the nature of holding of the land. So once the state has passed on the land, in what mechanism should the land be held? One school of thought is that it should be private title, full ownership, which is exclusionary. But another school of thought is that we should be looking at mechanisms that are similar, for instance, to communal living and communal ownership, in terms of which my rights to the land are not exclusive of your rights to the land. But that's in relation to me and you, but it's not in relation to both of us and the state. What I support is that the state should play no role, but at the same time, my rights should not be exclusive rights. The idea of private exclusive title has created enormous difficulties in places like Soweto, places like Mabubane, places like the Northwest, where they have, as part and parcel of this new program of giving everyone title. Question is, who should get the title? You have family members fighting over title. And the ways in which people hold the land, I think there is a space there for a real debate in this country. Our government's obsession with private title to the exclusion of everyone is probably not the solution.
But I mean, won't we also need some cultural rethink of how people get organized, even in terms of, because some of these families were broken many years ago through apartheid removals and all of that. Now you get them land and you're trying to get them to work together in a communal space, but their mentality has shifted from that kind of communality.
Yeah. I wonder if that's right, though, Mpumelelo, because the statistics in this country show that something like 22 million people live under a communal system already. 22 million people. That's half the population of the country. And where are they? They are in the former Bantustans, in the Transkei, in the Ciskei, in Venda, in Bophuthatswana, in Gazankulu, KwaZulu. They live already in a form of communal system. And what tenure exists? The tenure that exists there is not private tenure. They don't parcel out land and register it and get a title. The tenure that exists there is primarily customary, and the nature of customary tenure is communal. The problem is that when they get control of that land, the government superimposes a private tenure system on a system that is communal in its very nature.
Well, alternatively, they're having another difficulty, which you write about in one of the chapters, having to deal with the chiefs, who see themselves as custodian of the communal land. In fact, some of them, they go on to claim that they actually own the land, and they do deals with mining companies, with other, on behalf of the supposedly the subjects.
Yes, that's where the debate is. When we say that land is held on a customary basis, what does the custom actually entail? And there is a clash there, because some people believe the custom means the land belongs to the chief. In fact, the chiefs assert that the land belongs to them. And communities say that when it says custom, it means the land belongs to the communities. And sometimes a custom might mean that the land belongs to a particular family. You know? And so when I argue that we should purge from our policy thinking the idea of private title that is exclusive, I am also concerned about how we reform the relationship between citizens and chiefs, because the current chiefly model that we have in this country is essentially Eurocentric and imposed from the top. This was a system designed in 1927 under the Native Administration Act. In fact, its origins come even from the 1870s, when we had the very first Native Administration Act applicable in Zululand. And the reason why this was imposed is what Mamdani calls indirect rule. What the white government wanted to do, they just didn't have the time to control all the quote-unquote natives. They wanted to install one person to be in charge of all of the natives in an area. And the only way to control the natives, in others, to exercise political power over them, was to give the chief rights over the land. And that was then installed by legislation. So part and parcel of reforming land relations has been to thinking about how to undo that artificial relationship. So it's not even truly customary, but it was made customary by the British and obviously perfected by the Afrikaners, the proud successors of the British administration.
So is there a way of rescuing the land from such clutches?
Yes, there is. Firstly, the chiefs do not have title at the moment. There are some chiefs who have title. What happened in the areas like Transvaal, a bit of Mpumalanga, is that in the 1870s in Kruger's Republic, Africans were not allowed to own land and have it registered in their name. But they could be allowed to acquire the land communally.
Although the Uitlanders could.
Yeah, well, yes, and the Hollanders, by the way, could. But Africans couldn't, right? And so they could get the land on a communal basis, but it was registered in the name either of a white missionary.
Yeah.
And when the white missionary left, some of that land was registered in the name of the Native Affairs Commissioner. And when that left, that land was then registered in the name of the chief, right? The chiefs have now been the primary organs claiming that land back. When the land comes, it comes with the title in the name of the chief. But that is just wrong. But for the most part in the country, so those are isolated instances which I've found in the course of my research, particularly here in the Transvaal, former Transvaal. But for the most part, that land is actually registered in the name of the state.
Yeah.
And it is the so-called trust land. And the rules that govern that land flow from a piece of legislation passed in 1996 called the Interim Protection of Informal Land Rights Act, which is probably the strongest protection that communal people have over their land, because it protects people from dispossession, whether by chiefs or by government, without individual consent. That's the law that was used to protect the people of Xolobeni against the decision of government to dispossess them in order to allow a mine.
You know, one of the things that investors and people in banking sector and other places worry about is if you tamper with land rights in your attempt to redress the dispossession of the past, you might give people the wrong impression that you want to go the Venezuela route of nationalization. People can, I mean, whatever your good intentions, people receive it in different ways. And you might end up damaging the economic prospects of the people that are supposed to benefit from the process. So people often say, well, you should be careful of not to mess up your economy. And the banks often cite the extent to which they hold a lot of land as collateral for all of the financing that they've done to farmers. So farm debt over the years has been mentioned as one of the obstacles, if not the reason why you shouldn't take away land by expropriation means. So what do you say about that? I understand you also did that research around the extent to which banks are exposed to the land.
Yes, I mean, suppose two questions to be answered. I think in this country, the primary people that will oppose state ownership are not foreign investors or banks. It is the ordinary South Africans. They will remind you that they have been expropriated by the state twice. They were first expropriated by the British, who insisted that black land became crown land. Then they were expropriated by the Afrikaners, who registered their land as trust land. They are not going to tolerate another expropriation by a democratic government. So Africans will resist any expropriation of land by
the state,
through state ownership. They have had the experiences. My grandmother had the experience. I'm sure your grandmother had the experiences. So in this country, there is a different culture of affinity and attachment to the land, which will constitute enough of a basis for this kind of massive resistance to state ownership. So the people do not want the land for the state, they want it for themselves.
Is there a balance then we can find between having to expropriate without giving a wrong signal about where our economy is going, but at the same time achieve the purpose of redistribution, which is to settle the historical issues of property imbalances in terms of racial ownership? Is there a sweet spot somewhere there? Or it's impossible to find a sweet spot? We must just...
No, there is. Firstly, I mean, I don't like the language of low-hanging fruit and whatever. I mean, that always makes me feel very uncomfortable. But right now, at the moment as we speak, we have vast land in the so-called TBVC states, right, which is occupied, but where tenure is precarious. Ingonyama Trust, South African Development Trust, right? There is no reason not to strengthen that hold over that land through legislation. Right now we have the Interim Protection of Informal Land Rights Act.
You mean by confirming and making it a community-owned land?
Precisely, exactly. Making it community-owned land, which then dispenses with the myth that banks do not want to lend in relation to communal areas because title is unavailable, etc. So there is no reason not to do those things right now. The government has all of the legislative mechanisms to implement it. In other words, confirming the rights of those communities over that land and taking away the entitlement of chiefs to exercise that power wrongly. So that can be done immediately. If you are looking for a sweet spot, something that can be done in the next 6 months, that can be done. Secondly, on acquisition, which is what the debate on expropriation ultimately boils down to, which is, you know, how do you acquire in ways in which the concerns of the so-called market, you know, can be accommodated. We need to be interrogating. I mean, it's true. I've got a chapter that deals with banks. You know, we have to interrogate the lending models of banks. The traditional argument is that banks lend on the basis of collateral.
Of title.
Yeah, exactly. So they want title, but they don't want to take the title, but they use the title as collateral, right? But research that has been done shows that actually the existence of collateral is not the magic wand that banks will necessarily give you money because you have lent. What is crucial is income. You know, so we have
whether you can generate income on the land, or elsewhere.
Or elsewhere. You know, what's crucial is they want to see activity in your bank account. You know, so the most important thing in this country is income. What that means is that we cannot be looking at an exclusively land-based solution. We have to be looking at a totality of the solutions. There are also some examples. I mean, I make one example in the chapter dealing with women's access to the land. I make the example, in fact, from your own reference. An example of a community in the Eastern Cape. In
Qentane.
In Qentane specifically, which, you know, has been supported by the private sector despite the fact that the land is communally held. So in other words, banks themselves need to revisit their lending policies and their lending models. And they should have to recognize that the models that focus too much on land ownership on an exclusive basis are outdated models. We've got 22 million potential customers. And that if they took a little bit of risk with support, actually there can be some real meaningful change in communal areas.
Maybe as our last point of discussion, taking it further on the private sector, the role of the private sector, from the banks to the big commercial farmers and commercial enterprises in the agricultural space, people that are watching this show now, many of them wonder, what is it that they can do? They can see the state failures, that some of the issues we've highlighted that resulted in state failure and the constraints. And some of them, they will tell you, I don't know whether they speak the truth, but some of them, they will tell you that they've got a good heart. They wish they can do land reform on their own, regardless of whether policy makers are stuck in their bureaucratic wrangles or political rhetoric. They want to move on. They want to have settlement. They don't want to deal with the baggage of history. They want to go on with their commercial enterprises. And they're asking, what can they do on their own, regardless of what government does? Is there some advice you can give them?
Look, I mean, firstly, I don't believe that there is a large enough group of property owners in the farming sector who have that attitude. My own experience has been that property owners have resisted a land reform with every strategy that they can employ. They have resisted. So if we are to tell the truth about landowners in South Africa, the first problem is that they should change their attitudes towards land reform. And changing attitudes doesn't mean going to a conference and claiming that I never supported apartheid, I never voted for the National Party, I support land reform. What it means is that on the ground, they have to be doing things that are tangible. If it had not been for the resistance of property owners, I think much progress could have been made, because it's not the state's failure alone, it's the state's failure coupled with the resistance. You know that, I mean...
So both sides are guilty here?
Of course, precisely, both sides are guilty. I mean, if you look at one of the problems of corruption in the land space, who in fact is corrupt? I've had many cases in the Land Claims Court where I've discovered, when I've inspected the files, that the landowner is corrupt, the government officials are corrupt, the land claimants are corrupt. They all strike a deal.
All three stakeholders.
Yeah, exactly. They all strike a deal, which is completely artificial, where I keep making this example, or there are two examples that everyone can, relate to. The one is Malamala, we know in Malamala that the highest price evaluation came to something like 500 million or 600 million, I can't remember. But the ultimate price that was paid by the government with the consent of the landowner was R1 billion.
Yeah.
Right? So if we were talking about landowners that are genuinely interested in the welfare of South Africa, they would not have accepted R1 billion.
But wasn't that sold on the basis that, well, this is not just a land anymore, this is a huge commercial enterprise? I think that's how Malamala was sold.
Yes, but I'm saying the land plus the commercial enterprise was valued at 500 million.
Yeah.
But it was sold at R1 billion.
Yeah.
Right? And now what happened to that difference? You know, so the point I'm making is that the idea that government is solely to blame for corruption is not borne out by the evidence. So it was the private sector that engaged in that corruption.
The government just coalesced in that, we're just part of the bigger
Yes, I mean, maybe an official or two got kickbacks. I don't know what the actual facts are. And maybe someone from the community as well, a community of claimants also got, you know, an undue payment. All I'm saying is that it was the collation of those interests that resulted in the artificial inflation of that price. So that's the idea of changing the attitude is absolutely crucial. But you see, Mpumelelo, if you want to do land reform on a sustainable basis, the idea that you will depend on the private sector is just an impossible idea. It will simply never happen.
No, but I mean, we should assume that the people that are asking these questions, what can I do? Let's assume they mean well. What should they do?
But I believe, I'll give you now the things that they can do.
Yeah.
The reason I resist this is that I believe that if they exist, they are a minority.
Yeah.
Because in the real world, where I have operated in land claims, I have found them utterly obstructive.
Yeah.
And I found them to be employing each and every trick that they can employ to resist a land reform. Even today, in the current debates on expropriation without compensation, if you look at where the resistance is coming from,
it's coming from them.
It's coming from them, together with the banks. And they are raising each and every imaginable scarecrow. And then in a conference, they will claim that we support land reform. I mean, how do you support land reform but oppose it at the same time? I mean, the thing makes no sense to me.
Yeah.
But let's talk about what
can they do if they claim to be in the right space.
Yeah, what the 0.1% that is genuinely interested in this can claim. So, you know, I was in Stellenbosch about 2 years ago, speaking at a conference on land, which was attended by white farm owners.
Yeah.
I asked them, why don't they donate the land they have to the workers?
Yeah.
No one could answer. They claim that it's because there's no donations policy, but there's donations legislation.
Yeah.
And I asked them why they donate the land, and so to who? So forget it, don't donate the land to the government, donate it to the farm owner, to the farm workers. And they couldn't explain that. I asked them another question, why have you been evicting so many farm workers on spurious grounds and spurious charges? If you go to the Land Claims Court now, you look at their role. When I was an acting judge there, I think about 80% of my work was having to undo unfair evictions.
Yeah.
So I asked them, why have you been evicting so many people that you know have got nowhere else to live?
Yeah.
They couldn't answer that. So the second thing they can do is to stop the massive evictions that they've been engaged with on a continuous random basis. Every time they hear that expropriation talk arises, there's a wave of evictions. And you know how evictions are such a major problem in this country. It is said that we have evicted more people in the past 25 years than the entire apartheid period. That is a scandalous thing. During
that's shocking numbers.
Exactly. During the apartheid period, the numbers were 3.5 million. But the number of evictions post-1994 are said to be in the region of 5 million.
Yeah.
It is truly scandalous, right? So the third thing is training. They, you know, the idea of training might itself be a problematic idea. Because often they claim, oh, well, you know, we need to give you, you know, training. And yet if you go to a farm, you find so many African workers actually running the operation. What they don't have is ownership. You know, so again, even on that area of combining training with ownership, you know, that is something that
they just work well in their different, you know, functions, but no one has a bigger picture of organizing the entire enterprise. But somebody sits there and organizes the enterprise with the division of labor, who does that, but they have no sense of organizing themselves in the entire enterprise until such time that someone can leave the farm with them.
No, but that assumes that that is innate.
No, it's not innate,
Yeah.
but that's how the farmer has structured the farm.
Exactly. So, but if the farmer could structure the farm differently, there would be a different outcome.
Yeah, exactly.
But the reason it's structured like that is to entrench ownership,
Yeah.
and to entrench that pattern of dependency. So the fact of the matter is that farm owners do not want to let go. And I understand it, because every property owner works on a capitalist instinct.
But if that's the case, then in your view, then it means that the starting point is not really technical matters. The starting point is a mental shift.
Yes, but you will still find a difficulty in relation to what I talk about, the change of attitude. Because this attitude is largely driven by the material conditions. So I think until you have a capable state, right? A capable state, a state that is not corrupt, a state that is willing to drive a progressive constitutional agenda, then you are not going to have meaningful land reform. And we should stop obsessing too much about money. What is crucial for land reform is law. Is the process must be guided by law.
But I mean, what are the chances of having a progressive state when, I mean, you yourself had to make a ruling against a minister who was stalling on the District 6 case, and you even actually decided on personal cost order against the minister. So is there really hope among those who run the state to actually turn the corner?
Yes, what I mean by the state, I don't mean the government and I don't mean the minister, but I mean institutions of state. The true future of South Africa is in strengthening its institutions, which can outlive a change in government. One institution is the Restitution of Land Rights Act. It's focusing on the legislation that will make that institution a strong institution. Another institution is the Land Claims Court. So strengthen the institution, make it strong so that it can outlive the government. So if you've got strong institutions that can operate regardless of what the political class does, then you will solve part of the problem so that we don't depend. I mean, I made the one example earlier about how much dependency we have on property owners because they decide which land becomes available. They also decide the price for the land because they decide how much the land should be sold for.
They are the market.
Exactly. And they also prescribe who acquires the land. So they will decide this land must be owned by the government, this land must be owned privately. So that kind of veto that they currently exercise should be dismantled. It is not going to be voluntarily dismantled. But at the same time, it should not be chaotically dismantled. It should be dismantled by an institution of state that has constitutional powers and that can sustain a collapse in government.
But it has to be competent, otherwise there will be chaos.
Yes, there are certain elements that I recommend. One of them clearly is competence. Secondly is that there should be no corruption. And thirdly, it should be properly funded. Fourthly, it should be independent from government, and it should be independent from landowners, and it should be independent from land claimants. So it's about building capable institutions. And that would be the lasting solution to the problem of landlessness. But we should remember that the crucial thing that happened in Zimbabwe was when they turned their backs against the rule of law. They were always negotiating money in Zimbabwe. And you were never entitled to market-related, etc. But you could always negotiate the parameters of money. But what is non-negotiable is the rule of law.
Well, Thembeka, your book, Land is Ours, became a bestseller.
Yes.
And which it was well received in the market. And now, with this new one, which is provisionally titled Land Matters, I'm not sure whether the title will change. When should people expect it? When is it coming out?
It's coming out in January 2021. It will definitely be on the shelves in February 2021. So it's coming out in end of January 2021.
Well, let's hope it's not too late for the policymakers to get some insights about possible solutions to our very, very intractable problem. And
I mean, we lost the land over 360 years, so a couple of months is not going to be hurtful.
Well, it's worth waiting for the book, and that was it between me and Thembeka Ngcukaitobi. Thank you very much for watching. Until next time.